Well, good evening, everybody. My name is Kate O'Regan, as I said a moment ago, and I'm the director of the Bonavero Institute of Human Rights at the University of Oxford. And I'm really delighted to be welcoming this very distinguished panel this evening to be discussing Joshua Rozenberg's new book, Enemies of the People, How Judges Shape Society. A warm welcome to Joshua. Joshua is the only journalist, I understand, who has been awarded the title of Queen's Counsel Honoris Causa. He's an alum of Oxford, and he has worked in the field of legal journalism for many years. In addition, on our panel, we have Lord Thomas, the former Lord Chief Justice in the period 2013-2017, who could in some ways be said to have been responsible for the title of Joshua's book, about which Joshua will say a little more in a moment. He is currently president of the Qatar International Court and an arbitrator at Essex Chambers. Then we have with us Helen Mountfield, QC, my colleague at Mansfield College, who's the principal of Mansfield College and an experienced and award-winning barrister with over 26 years experience in constitutional law, human rights, and equality law. And finally, last but by no means least, is Professor Paul Craig, the Emeritus Professor of English Law at the University and a fellow in English Law at St. John's College, Oxford, who specializes in constitutional law, administrative law, and EU law, as well as comparative public law. This is a wonderful panel to talk about this important book at this particular time. And I'm going to start off by turning to Joshua and saying, it's been a kind of dramatic year, a dramatic couple of years in relation to public law in the United Kingdom. Your book talks about the two famous cases relating to Brexit, Miller and Miller-Cherry, but it doesn't talk about some more current events, such as the establishment of an independent review of administrative law by the current government, and also recent occasions where both the Prime Minister and the Home Secretary spoke out about lawyers who represented people who are challenging decisions for deportation, for example, which resulted in an extraordinary letter written to The Guardian, signed by 800 senior lawyers, including 3 former members of the Supreme Court, basically asking for an apology from the Prime Minister and the Home Secretary for what they sort of classified as attacks on the legal profession and on the rule of law. So, these are dramatic times, and in many ways your book is engaging with the important question, which is, what is the role of judges in the British democracy, and is what they do an overreach? And I wondered whether, you might explain to us why it is you wrote the book, and also perhaps reflect on whether, having written it and having been such an astute observer of law in the UK over the last many years, you are concerned about the rule of law in the United Kingdom.
I'm certainly concerned, and it's right that we should keep an eye on it. Thank you very much for inviting me, Kate, and thank you for your questions. Why did I write the book? Well, I'm a working journalist. Bristol University Press approached me and said, we do a series of titles in social policy. We want to do a book on law. And I thought, well, social issues, law, what about how judges make law, how judges develop the law? And I'd also been asked to give a lecture in Belfast. This was in 2018 when they approached me. It was coming up, and the people in Belfast, Human Rights Commission, had invited me to give a lecture called Are Judges Enemies of the People? And I thought this would be a good title, and once you've got the title, off you go with the book. And obviously I'd had Miller 1, which generated the title, and just as I was finishing the book, just over a year ago, along came Miller-Cherry, as you refer to it, Miller 2, as some people call it, and so the book is bookended, if you like, by Gina Miller's 2 cases, and very interesting they are. So yes, I think that these are concerns that you've raised. If you go back, you have seen politicians criticising judges in the past. Michael Howard had a go at John Dyson when John Dyson was a High Court judge, for example. I mention it in a book. John Dyson mentions in it a book. And this sort of thing happens. John Reid, when he was Home Secretary, David Blunkett. I mean, there have been politicians attacking judges in the past, and it's very unfortunate. It doesn't usually get much further than that. it is extraordinary, isn't it, that you had the Supreme Court taking some quite powerful decisions quite recently. I'm thinking of the Privacy International case, the summer of last year, which affected the relationship, if you like, between the courts and Parliament, and nobody took any notice. Nobody said, "Oh, what about that chap, Lord Reid, who's Deputy President and might be in line to become President? Do we need to look at him and his political background?" So I don't think you want to exaggerate it too much, but certainly we should be concerned about all these things.
Yeah. Well, thank you for that. I mean, one of the things that I really enjoyed about the book was that you, as you say, you bookended between the two Miller decisions. But in the rest of the book, you traverse a wide swathe of laws, criminal law, family law, human rights law, and show that effectively judges are faced with difficult, quite often very sensitive decisions in all sorts of areas of the law outside of constitutional law and kind of public law. And my sense is that your view is that judges can't avoid this, and that also that you think that by and large many of these decisions have been right. I mean, maybe you might like to talk a little bit about, should we take the interesting decision in Radford, the parole decision, in which you feel that the court actually reached a decision that was not only you thought correct, but which was one that was actually widely seen as correct. Following, perhaps you might just fill the audience in a little bit about.
This was the black taxi rapist, and the problem was that the parole board had decided to release him in circumstances where just about everybody, apart from the three, I venture to suggest, inexperienced members of the panel of the parole board, thought that he should remain in prison for much longer. And this came before Brian Leveson as president of the Queen's Bench Division, who was facing something new, because until then a parole board decision hadn't been challenged by the potential victims of the prisoner. Plenty of prisoners had challenged decisions not to let them out, but you hadn't had a decision by people who were not prisoners challenging the parole board's decision to let the prisoner have parole. So the first question was obviously whether they could do that, and the answer was clearly yes, although he took a very narrow view of standing and said that the Mayor of London didn't have standing to challenge the decision of the parole board, and this was perfectly pragmatic. The Mayor of London simply came in because it looked at one point as if nobody would, and Bradford could be wandering around London and endangering people in London, and therefore he thought he ought to intervene, but the court didn't have that. But the much more important thing was the way in which the court, under Brian Leveson, fashioned a judgment which succeeded in doing what everybody thought was just, which is to ensure that the prisoner remained in prison for much longer, on the basis that even though he hadn't been prosecuted at that time with other offences, he was suspected of many, many other offences. But at the same time, he avoided opening the floodgates to lots of challenges, and indeed that was successful. There haven't been challenges by victims to any great extent, although there was a decision by the Divisional Court at the beginning of September about a man called Sims who was granted parole, and in the name of whose victim Parliament passed new legislation yesterday which has no effect at all, but simply requires the parole board to do what it does anyway, which is to consider circumstances where a killer or somebody who takes indecent pictures of children refuses to identify where, in the case of a killer, the victim is buried, or in the case of the pictures, the subject of the pictures. So what I'm trying to say is that this was a pragmatic and practical way in which it seemed to me the courts fashioned a judgment which was clearly just.
Thank you. So I'm now going to turn to our panelists, because I know that they have many things they'd like to say. Lord Thomas, could I turn to you first to comment on the book?
You're on mute.
You're on mute.
First, I want to say how valuable this book is. Its sweep is enormous, but its primary benefit, I think, to everyone is that it tries to explain how judges do their job. And the principal focus, of course, is lawmaking, but it's a lot more than that. And I do think it's important to realize that unless judges command confidence and trust and their role is explained, their job becomes very difficult. One of the great achievements of the English legal system has been its achievements in commercial law. And it's from the time of the 17th, 18th century onwards, it's always been able to command the confidence of the merchant community. And when it hasn't, it's soon been put right, such as with the establishment of the commercial court at the end of the 19th century. And that's pretty easy because they're dealing with a small group of homogeneous people who can make their views very easily expressed. But now, how do you make judges and their role understood and respected and above all trusted? And I think things are a lot more difficult than they were even 4 years ago when I was named an enemy of the people. When Brexit is now made worse, for example, by the disputes in the current bill before Parliament on the UK internal market bill about the rule of law. There's enormous concern about the power that government ministers have taken to legislate really without much consultation until recently without going to Parliament. Devolution is becoming a very serious issue in holding the union together, and there's very little attempt to see how the judges knit into that. I think there's a lack of respect for conventions and, of course, attacks on lawyers, which Kate Regan has mentioned. So I think life's much more difficult. And it's even made more difficult by what I think can be seen as a fairly clear agenda on the part of this government, which is to try and clip the wings of the judiciary. I've got no doubt that's what the aim, but whether it will succeed or not is a very different question of the current review of judicial review. The potential of having a look at the Human Rights Act, and of course, will they turn and look at the role of the Supreme Court? But there are more subtle ways. One is the way in which you direct funds through the criminal justice system. You starve the court of funds. You don't provide legal aid. And so the position is, I think, acutely more difficult, as I just feel I had a relatively easy time. It's now much worse. But how do we deal with this? I don't shirk from saying the judge's responsibility is primary. And I'd like to add to what Joshua said about the black cab rapist. I mean, Brown Levison's judgment in that was the model of what you should do. You explain it simply, you set it all out, and you think, what impact is this to have? And so the way in which you craft and write judgments is absolutely central. And I'm not certain that it's always easy to get over to judges how important communication is. Because if you don't get your judgments right and communicated, you start with a very sticky wicket. Secondly, it seems to me judges have to run an efficient show. And if you look at Poland, and talking to people in Poland, what has happened there has been badly run courts, which then the government there has been able to seize on to attack the judiciary and fundamentally undermine them. Mr. Orban in Hungary has done very much the same. But it's also important that in areas such as family law, which is now very much to the fore, and sentencing, which is coming back with an increase in the length of penalties, that judges do things in a way that commands confidence. I think my own view is if the government attacks the judiciary must directly defend itself. It has to pick a time of its own choosing, but it's got to do so. But it's got to be careful, I think, about three things. First of all, it's got to get the right relationship with the press, the government, and with Parliament, and bearing in mind the narrower focus from which judges are drawn. I think sometimes this is very difficult, and although people try and do things about it constantly, it's a problem. Secondly, there's the subject of the book. Where is it right to castigate decisions as political ones? I personally think that an awful lot of the castigation is virtually misplaced. And three, I think there's the role of retired judges. I am under no illusions that whenever I say something, the picture immediately produced is one's wig. You can never get rid of it. And I do think it's very, very important that retired judges realize the damage they can inflict on the judiciary by not appreciating that the people see them as speaking as judges. And so what about this book? What about the book, and how does it help? Well, I take the view that the judges really do need strong defenders. One of the obvious defenders should be government ministers, but that's been sadly lacking of late. It should be Parliament, but I'm afraid Parliament is being sidelined to an extent that is deeply regrettable. And so we need to engage, and the judiciary needs to engage more with the media. And that's why this book is so important. It's readable, it explains it all. One might not agree with everything. If I agreed with everything Joshua said, I think he'd be very disappointed. And I'd be very disappointed if he agreed with everything I said. I think a critical friend is essential. And he is the critical friend. And we need people like that. And one point when we get to it, I'd like to ask Joshua, how do we create new Joshuas? I'm not going to say he's getting old. That would be wrong for someone of my age to say. But it is of note that, you know, some of the great legal correspondents, Francis Gibb, Clive Coleman, have either retired or are retiring. We've got to have young people. Their training ground used to be courts, going there, listening to cases. That's virtually gone. Because courts newspapers can't afford it anymore. And how do we get defenders like Joshua for the future? Because they are irreplaceable. They're needed by the judiciary to explain to people in a dispassionate and not in a way that is sort of praise, but a rational, balanced view. And a book like this, it's wonderful. I'm not going to say please write more, but what I'm more interested in, how do you find the young to carry this on and strengthen the tradition of the judiciary, which is now, I think, in this country, although nowhere near what has happened in the States, or in countries like Hungary and Poland, of which I've spoken, there is, I think, a real problem of it needing defenders.
Thank you very much, John. Joshua, would you like to respond immediately to a couple of, particularly the last very direct question?
Yes, I will. You're quite right, John, that there is the people like me are dying out and not being replaced because the news organisations can't afford us. But there is one hopeful sign, and that's the rise of the legal bloggers and tweeters who develop, for example, the individual known as Secret Barrister. I shall refer to Secret Barrister as SB to avoid any pronouns that may give anything away. And SB started as a blogger and as a tweeter and has a huge following, much larger than I do, and has written 2 books. Now, SB certainly takes a critical view of all sorts of things, and not everything that SB says I would necessarily agree with. And SB is a working barrister and therefore doesn't have the opportunity to sit and read judgments and go to press conferences or do all the things that a journalist can do. But SB and people like SB do a great deal to help the public to understand how things work. Now, there are pitfalls. There was a judgment from Mr. Justice Nicol on Monday, and the judge did not provide a press release, even though the judgment was, 160 pages. This was Johnny Depp, of course. But we were told that the last paragraph of the judgment summed it all up, and indeed it did. However, the judge wrote it in a very slightly curious way, such that if you just started with the last paragraph, you might get the wrong end of the stick if you were not reading it carefully. What he said was that Depp had proved his case, but the Sun newspaper had established the essential truth of what they published, and therefore Depp lost, and the question of malice didn't arise, which is, a perfectly good summary of what the judgment was. But the way in which he said it seemed to suggest to some people that, Depp had really won, and it was only on a minor technicality that the Sun had proved that what it said was true, and he didn't succeed on malice, But of course that was irrelevant, and that was perhaps put in for the benefit of American viewers. So it's terribly important to get these things clear. And Lord Thomas knows that in my book I regret that in the famous judgment which led to the headline Enemies of the People, the judges did not spell out the fact that they were handing power to Parliament. They did not make it clear that all that was necessary was for Parliament to pass legislation, as indeed it went on to do with no difficulty at all. It had a majority, the government had a majority, and once Parliament had passed the legislation required by the judgment and supported by the Supreme Court majority, then of course the government could, as indeed it did, trigger Brexit. So if the judgment or a summary had actually said this, I speculate on whether it would have made any difference to the newspapers. Possibly not. Possibly they were going to publish the sort of things they were going to publish anyway. But nevertheless, at least the court would have explained itself in a way. Perhaps that's not appropriate for a court. Courts don't normally say what happens next. Courts don't usually sell their judgments. They explain them. But nevertheless, the more the courts can do, the more easy it is for people like me and all the bloggers and the other people who comment on these things to explain these things to the public, sometimes rather quickly.
Thanks very much, Joshua. Now I'm going to turn to Helen Mountfield. Helen.
Yes, well, I wanted to join John Thomas. It's great to be with an arch enemy of the people on this panel, but I wanted to join him in saying what a fantastic book I think this is. I will be pressing it on students at Mansfield, especially those who haven't done law as a first degree, because I think it really articulates very clearly the important issue about the role which judges play in our democratic society, which I believe, and I think you believe, Joshua, is to protect that society. And it also explains very clearly the row, which is put in very simple terms in most of our media at the moment, which as to the extent of that role, because I think it's entirely proper for people to criticise particular judgments and the balance in which judges reach in particular cases. And I think it's proper and important also for judges themselves and our society to think about the assumptions and prejudices that judges bring to that decision-making process. And that's why I think the sort of debates we have about the diversity of our judiciary matter, not because I think all working class origin judges decide things one way or women or anything like that, but just because I think it's important for everyone to examine the presumptions they bring to decision making. But what I think is very regrettable and worrying is the whispering campaign, the murmuring judges really that goes on to suggest that isn't really what judges are doing. And there are some judges who are politicians manqués, who are actually just trying to play out their own personal politics through judgments. And while I think there are judges whose approach to controversial cases I admire more than others, I don't believe that any judge thinks that's what they're doing. And I do think it's very important that the executive, the government, respects the constitutional role of judges, genuinely respects it, and as Lord Thomas says, stands up for it. Because I think that's what judges do, whether or not they criticise particular decisions by the executive. I think that what they are doing is protecting actually the sovereignty of Parliament, which they take terribly seriously, because they are looking at what a statute is meant to mean, but also what considerations the legislature can be assumed to have expected the executive to bring into play in a particular context. And without that role, then I think the executive becomes overpowerful. And we have actually, originating in this university, a project which has enormous media power, I think, the Judicial Power Project, which is known to many, and I think with some justification, actually is the Executive Power Project, because it's a criticism of an ostensible power grab by judges. But the logic of what those commentators say is that once a government's been elected, they should be allowed to get on with it, and no one should really be holding them to the rule of law or holding them to the international agreements which one might presume they are seeking to underpin what we do. I also think that the title of Joshua's book is well chosen. I'm glad it has the question mark.
Question mark, yes.
The question mark on it, Joshua, because I do remember the enormous shock of the day of the Divisional Court judgment in Miller, partly utter delight at winning after I had met you, Joshua, when I was halfway through my submissions, and you said, "You're not going to win this one, are you?" You own up to in the book. I thought, well, thank you for the vote of confidence. I still have some things to say, but I'll keep going. But partly the delight and shock at having won, but also real, genuine shock at the vitriol of the headlines. And I do think it's significant. This is not the first time that the headline "Enemies of the People" has been used. That headline with mugshots of the judges was used in 1936 by the Volksche Beobachter, which is a Nazi newspaper. And it does matter. It is actually dangerous when judges or lawyers are attacked, not for the judgment they bring to a particular case or the way that they do something, but for their role, for performing the function, which it is their function to perform in society. And you know, the attacks on lawyers have been physical recently, so it is a dangerous thing. The other part of the book I thought was really fascinating, and it's incredibly wide-ranging. But the other part that it articulates very well, the role of the courts in the very controversial social and economics rights cases which have happened during the austerity period. And Joshua, the case you focus on is McLaughlin, which was a case where a widowed parent, mother of 4 children, couldn't get a widowed parent's allowance because she hadn't been married to the father, or because she hadn't been married at the time of her partner's death. And I think you very clearly articulate the distinction between the view of the majority, which was essentially that the reason this was unjustified discrimination was because the relevant factor was this is an allowance you get for being a parent, and the nexus is between the contributions made and the children who are to be supported by it. And Lord Hodges' approach, which was that the nexus isn't with the children, the nexus is between the person who pays the contributions and their partners. That's the nexus. And then you look at what the factors are. And I just think if people understood the very structured way that judges think, then I think they would have a lot more respect for the role. And so it's an incredibly valuable public function that you've performed. And as I say, I shall be pushing this book into the hands of anyone who says, I might want to be a lawyer, and say, well, see this one, see if that's what you think.
Thank you.
Thanks, Helen. Anything you'd like to respond to in that, Joshua?
No, just to say thank you very much indeed. I mean, that is very, very kind of you to say that. I have written the book for people, starting out, or for people who are not lawyers and are interested in how the law should work. I mean, that's partly because that's my own level, and it's I don't aspire to anything more significant. One thing you do, I'd forgotten, Helen, that I said to you, as I'm very good at getting cases wrong and predicting wrongly how they're going to go. And yes, I probably did think, and I said the same to David Panic more than once, that and the reason behind it was my feeling that the risks to the judiciary of appearing to block Brexit were so great that I genuinely thought they wouldn't do this. To some extent, I did have in mind the consequences which resulted from the judgment. I did think it would be misunderstood. And I did think that the judges, although of course they obey their oaths, and of course they uphold the rule of law, and of course they decide cases in accordance with the law, I think the judges are very sensitive to the public mood, particularly those judges who head the criminal courts, and I include Lord Thomas. They have an idea of what the public expects. I remember very well a case when Lord Judge was Chief Justice. A court had passed a sentence, locked somebody up. I think he was acting in self-defense or defense of his family, and there was an outcry. And eventually his lawyers got round to saying, you know, on behalf of this guy who'd been locked up, you know, what about permission to appeal? And the message came back, we've already listed it for next Tuesday, because, you know, the courts are very sensitive to things going wrong which are going to damage public confidence in the judiciary, and are very keen to put them right quickly and effectively.
But I think it's, Joshua, I think you're right that judges should explain themselves. I think it's very helpful, for example, that the Supreme Court now has a press release summarising a judgment, effectively their own head note that goes out when a judgment is released. And I also thought it was very interesting in the first Miller case. I think, you'll correct me if I'm wrong, Lord Thomas, but that's the first time that the court issued a simultaneous transcript that came out that came out every day, which meant that a dinner party on the Friday evening, a well politically informed friend could kind of grill me on it all. But the effect of that also was that between the Divisional Court judgment and the Supreme Court judgment in Miller, and the Supreme Court obviously heard it very, very quickly, the entire academic legal blogosphere had read all the proceedings. They hadn't just read the judgment, they'd read the whole proceedings, they'd seen the skeleton arguments. And, you know, there was no good academic lawyer worth their salt who hadn't put something on the UK Constitutional Law Association blog about this, often 2 or 3 things, so that by the time it got to the Supreme Court, it was almost a discussion between the academic world and the judges, as well as the barristers. And that was an interesting approach, which I don't think has happened in a previous case I've seen, that the academics weren't commenting afterwards. They were part of the conversation.
Yes. Yes, I mean, that's right. I don't want to stop Paul getting in, but I'll just speak very briefly on that. That's very important, and it's changing, and the role of academics is changing. And after all, you know, it was the 3 academics who started that particular ball rolling. The one point I just would add, there were several differences between the Divisional Court and the Supreme Court. Things had moved on. The world hadn't collapsed as the newspapers predicted, and so on. But there was one very significant difference, and one very unfortunate difference, and that is that it is not possible to broadcast the proceedings of the Divisional Court. Now, as Lord Thomas knows very well, if he's sitting in the Court of Appeal Criminal Division in that same courtroom, it can be broadcast. But if he is sitting with the same judges in the same courtroom as a branch of the High Court, it can't be. And yet, because these cases, the 2 Miller cases, leapfrogged the Court of Appeal, and because the quality of the Divisional Court in terms of the seniority of the judges was as high as it was possible to imagine in both cases, it was the equivalent of the Court of Appeal, and yet it couldn't be broadcast. And I think the rules should certainly be changed to allow the possibility of broadcasting cases from the Divisional Court.
It's amazing how quickly those views have changed. And if you just went back 10 or 15 years, people would have been quite shocked at the idea of broadcasting courts, but it really has become a hugely valuable public educational tool. Paul, yes, sorry, Lord Thomas.
I just want to chip in with one comment. It's taken a long time to persuade judges of the benefits of broadcasting. Part of it's the result of there being no newspaper reporters in court. But I think Helen is right. This was the first occasion in which we did it, and it's a great, but it was restricted because of the task of bringing the judges with you. We also did a press summary, and we did spend, I wouldn't say as much time as writing the judgment. And I do take up on Joshua, you know, there were different things one could have done with the benefit of hindsight, but in any controversial judgment these days, you have to have a summary, and you have to run it past someone who knows nothing about the case.
Thank you. Paul, I'm going to turn to you.
Thank you very much indeed. Really interesting conversation, and it's great to be part of it. And Joshua, let me begin by echoing what Lord Thomas and Helen and Kate have said. I too very much enjoyed the book, and I think it's been very valuable. It is a very valuable contribution to an understanding of how courts reason, which is readable by the interested public, and it doesn't have to be someone who's done a law degree. And I'll come back to the structure of the book and what you say in a moment. But I really did think it's performing a tremendously valuable role in that respect. And I don't think there's anything really quite like it. So well done, excellent. Could I begin with two very different kind of questions back to you? One is, I understand that of course you read law at Oxford and you then became a solicitor. Whence or how did the transition to becoming the full-time legal journalist, as it were, happen? I don't know. I'm just really interested. I wonder if you could just.
I'd be delighted. No, it's a jolly story. I did law. I clearly was not going to be good enough to stay on and do the BCL, the second degree. I went off to a little solicitor's firm in Richmond, Surrey, where I did all the things that trainee solicitors do, and then the turning point of my life was in 1974, when some friends came round, one of whom worked as a secretary at the BBC, and told my wife, who was then training to be a journalist on a newspaper training scheme, that the BBC had a training scheme for journalists, and was my wife interested in applying. My wife said she was very happy with newspapers, and I think it was my wife rather than the friend, although memories differ on this. My wife said to me, well, why don't you apply? And, at that age, you're still young enough to consider changing your life. And it sounded rather glamorous. It said candidates will be required to take a voice test, and all that sort of thing. And it was heavily oversubscribed, as people like Helen, who run colleges full of students who all want to go off and join the BBC, will know very well. But the chap who was responsible for shortlisting the candidates was a newspaper man of many years standing. And he thought that it might be useful to the BBC at some point in the future to have a journalist on its staff with some knowledge of law, somebody who'd done a law degree, but more to the point was training to be a solicitor. I finally qualified, but not until after I joined the BBC. So I therefore got shortlisted and was able, as a result of regurgitating the information I picked up from my wife when she came home and told me what she'd learnt during the day at her course, I was able to persuade the people who were selecting this that I knew enough about journalism and got on the course. And I did all sorts of journalism for 10 years, from 1975 to 1985, before somebody at the BBC decided they wanted to have a legal correspondent and to present a programme called Law in Action. And like most of journalism, the trick is to be in the right place at the right time, and I was. The miners' strike was going on in 1984 when I was being tried out, and that was the last piece of politics which depended on the law, not just the role of the sequestrators coming in to seize Arthur Scargill's funds, but this was a political event, Mrs. Thatcher's fight against the miners, which depended a great deal on analysis of utterly obscure bits of law. And so, I found a useful role, and by the time they confirmed my appointment as a legal correspondent, because it was probationary for a bit, the miners' strike was over and I was in. And so I did that for 15 years, and then the Telegraph made me an offer and I left the BBC, but came back to do Law in Action and so on. But it's just, if people ask you to do things, try and say yes, take opportunities when they come, because if you don't, you always regret it. I know pretty well what would have happened if I'd stayed being a solicitor. I had no idea what would happen if I joined the BBC. I had no knowledge whether I was going to be covering law or anything else. Take opportunities when they come, otherwise you always regret it. And if they turn out wrongly, well, at least you tried.
And they didn't turn out wrongly. We have this wonderful book and your many, many insights which led up to the book. Kind of my second question is coming back to the title of the book and the subject matter of the title. Again, it's a question back to you, and it's a question I've always been interested in. It seems to me you're probably better placed to know the answer than anybody else, which is, if I can put it bluntly, how far do you think the newspaper was just selling copy, by having this dramatic title? And how far do you think they just didn't understand the key point about the fact that the court was not arrogating power to itself, but adjudicating on a division of power between legislature and the executive? I mean, so selling copy or not understanding, or a bit of both? Which was it, do you think?
I think the fair answer is a bit of both. Just to expand that, the Daily Mail at that time was edited by Paul Dacre, who was a brilliant newspaper man. He's still, involved, but he's no longer editor of the Daily Mail. And I think that had something to do with the headline and the story that we're talking about. But he had a brilliant eye for headlines and for how to sell newspapers. And he designed the headline, he designed the front page, he told the reporter what to write, I'm sure. So he had a strong say in that. And of course, he wants to sell papers. But he also, I suspect, did think that this was going to block Brexit, which he supported. He supported Brexit, and he was therefore against what the court appeared to have done. Now, whether you could have persuaded him that this isn't going to block Brexit, if you told him that on the day that he was writing that headline, I don't know. I suspect not. I suspect he would have said, well, if the momentum goes, if it goes to MPs might change their mind, MPs might be got at. We know what MPs think, and they're not supporting Brexit anyway. They feel they perhaps need to go along with the referendum result. But they certainly, might try and block it. It's going to take time. He would have been genuinely concerned that the Divisional Court's decision would have, in some way, thwarted what he saw as the view of the people, the will of the people, as expressed through the referendum. And it's fair to say that he was not the only one to publish a headline like this. The Telegraph had a similar one, pale imitation. The Daily Express went completely over the top. I quote them all in the book. And the newspapers did feel this. So it wasn't just him. It was several. Helen, are you holding your pen up because you want to comment?
No, I mean, it's interesting that you say that was a Paul Dacre headline, because I'm sure you're right, because you're much more inside track than I am. But I understood that the piece was written by James Slack, who then became the Prime Minister's official spokesman in February 2017, and indeed still is the Prime Minister's spokesman. Yes. And I started to hear, I mean, you mentioned going back to James
James Slack.
No, but we'll go back to David Blunkett and Labour.
Yes, and Lord Reid, yeah.
There have been criticisms of judgments which people don't like. But I started to sense from about 2010, from civil servants and people I knew in politics, that there was a real visceral fed-upness with judicial review and the desire and the sense that it was stopping things happening, and that it was, there was a kind of political plot. And I just wonder the extent to which James Slack was somebody who, never mind the politics of Brexit, thought that actually did viscerally think this is an inappropriate use of the judicial role. There does seem to be quite a concerted attack on judges. And I don't know if it's the good old days that I'm just making up.
No, I'm sure there's something in that. I don't know James Slack. I've never spoken to him. I don't know what he thinks. But I do know that if you work on the Daily Mail, at least under Dacre, so if you worked on the Daily Mail, you had to do what Dacre wanted. You had to write the stories that he wanted in the way that he wanted. I had some of this on the Daily Telegraph as well. So it's not just the Daily Mail. I left the Daily Telegraph when they published a story under my byline, which wasn't true. And a member of the Supreme Court pointed that out to me. And I thought, I can't put up with this, and I resigned. Newspapers and particular editors on particular newspapers have a very clear idea of the story, and they take the view that it is their prerogative as editor to tell the correspondent or the reporter, this is the way we want the story written, this is how we see the story. Now, from the editor's point of view, they are more experienced as journalists and they see the story in a particular way and they want the story to reflect that. But no, I'm confident that Slack will have been told the way that Paul Dacre saw the story, and he will have written the story to fit the editor's preconceptions. Whether he has that personal view or not, whether there was concern about judicial review or not, I'm sure there was. I think this was very much from on high, and this was very much Paul Dacre.
Can I just add one comment? I'm not going to express my own views about it, but I don't think we will actually know what happens until someone can look at actually the papers that passed between the various ministries, because it was very odd that very little was said by the government. But whether such papers exist these days, that's another question. But there is a lot to this story that is unknown, but I'm not going to say any more.
No, I mean, there is a quote from Paul Dacre in my book, which is sometime after the event. He hasn't spoken about this very much, but he did speak to the Society of Editors in November 2018. He still maintained that newspapers should have the freedom to write a headline like Enemies of the People. And then he says, the title of an Ibsen play, and I put a footnote to say that that wasn't quite the title and it was meant ironically. The title of an Ibsen play, it was meant to be a distillation of the views of Brexit MPs angry that the High Court was becoming involved in the political process. And then Dacre continues, in retrospect, the Telegraph's banner, the judges versus the people, was, to coin a phrase, a tad more judicious. But what the hell, the point needed to be made, and it was the Mail's headline, not the almost identical Telegraph one, that, as happens so often, put an issue on the agenda. So that's what, and I say, and one might add, did the damage. So that I think answers Helen's point. He wanted a headline that would put the issue onto the agenda. So he wanted to sell the story in this way. And when he says it was meant to be a distillation of the views of Brexit MPs angry that the High Court was becoming involved in the political process, that's pretty disingenuous, because of course he will have rung up these MPs and say, you know, are you angry? If so, tell me, and I'll quote you, and you're in the paper. So, you know, he could have quoted the views of MPs who were not angry. So it's a little bit, this is how news is made. Sorry, Paul. I haven't really given you a chance to ask me any more than.
No. This is, look. I mean, the discourse, the discussion about, prompted by that question, was fascinating and really very interesting. I mean, let me just ask you one follow-up question, which is related to that. And you, in a sense, opined about this already in answering another point, but let me just ask you directly. One of the things I'm always been surprised about, and Helen, having been involved, may know more about this than I do, is this. One of the things I was always surprised about when Miller 1 went to the courts is that, forget the law for the moment, I'm just really surprised that the Prime Minister bothered to fight it, in the following sense. Any legal advisor talking to the Prime Minister ahead of the case could not have said anything other than, you might win, you might not. And, you know, maybe 50-50, maybe less than that. But no person could possibly, no legal advisor advising the Prime Minister could possibly have said to the Prime Minister, this is a slam dunk case, you're going to win this, hands down. It's just simply implausible. In which case, what I'm rather surprised about is that the Prime Minister bothered to take it to court. I'm actually just more surprised. This is before the, as it were, disastrous Theresa May election, when she lost some of her majority. So she had the numbers. And as we know, even after the case, she got the bill through Parliament, a two-line act, as it were, and notwithstanding some opposition in the House of Lords, it went through the Commons on the nod, as it were, and she got the mandate. I'm just surprised that she didn't just say, didn't save 6 months of Brexit time, if I can put it that way, and just take the two-line bill to Parliament at the time. She would not have had to admit, that we couldn't do this through the prerogative. She would not have had to say, we don't have a prerogative power to do that. She would have said, politically, we're not conceding that at all. We're just deciding that it's judicial, or judicious rather, to get parliamentary authorization. She would then have had the legitimacy of the parliament behind her, which is what she got post the case anyway. So I'm just wondering, do you, or either you or Helen, have insights as to why she bothered to have this fight?
Well, I'll just comment because I want to hand over to Helen and ask her the question. She's the barrister who's represented litigants, but it strikes me that Mrs. May was behaving not like a prime minister, but like a litigant, because of course she took this approach twice. First of all, she fought it in the Divisional Court, and secondly, she appealed. You know, Paul, you're crediting her with behaving like a statesman who is acting in the best interests of the country to save 6 months in a dignified way, in a way that avoids the risk of defeat. I'm suggesting that she is behaving like the sort of litigants that Helen must have represented, who are absolutely determined to push on and fight in the face of all the advice that the case is hopeless. Helen, you must have had people like that.
Well, yes, but one of the things about representing public authorities, at least I always used to think, in most cases, was that you would tell them what you thought was arguable, and they would recognise it wasn't about winning at any cost. I don't know what legal advice Mrs. May got, and if I did, it would be privileged. I was on the other side, but I can see why, perhaps why she fought at first instance, because most academic commentators were saying she would win at first instance. They sort of shifted around after the first instance decision. Perhaps the reason she fought it was that she didn't want parliamentary scrutiny of the deal and the process, and that she thought that the official, I mean, it may be that she was just being stubborn and didn't want to have lost, but it may be that she felt that if she had to get things and the deal and the nature of the deal scrutinised by Parliament, that could be problematic, as indeed it ultimately proved for her and Boris Johnson, and that the reason she did hold the disastrous second general election was because she wanted to strengthen her mandate to avoid having skirmishes on details of things, given that any form of Brexit was going to be attacked from both sides, from those who didn't think it was a good idea at all, who were then the majority of Parliament, and the sort of ultras, the European Reform Group and people. And maybe she thought, I just actually want to do this, me and the civil servant saying, here it is, it's a deal, and I say.
And then the other aspect of that is that if you're Prime Minister, you have to appear tough. You have to, take fights on and not give in. And she would have seen legislating as giving in to the complaints against her, certainly at first instance by these academics, and who's Gina Miller, and, how come, and so on. So I suppose the instinct, if you're the leader, is to fight and fight on and not give up till you have to. I don't know.
But what I don't think, and I mean, it was she who made the famous conference speech about the immigrant who was allowed to stay in the country because he had a cat, because it did prompt the Judicial Press Office, whatever it's called, to issue
Yes.
a correction, a rare correction. But what I think has become worse under the current government is an attack on the legitimacy of the judges. I mean, a deliberate attack. I think the repeated references to activist lawyers, for example, I think it's a bit of a dog whistle, and I think it's very, very dangerous once a Prime Minister puts himself on the side of the people against both the judiciary enforcing the law, and lawyers who take cases in the proper performance of their functions, and before the last general election when he had a landslide, also Parliament. Once in our system you have a government that says that it is the sole voice of the people, and that legislators who oppose him are traitors, and judges who oppose him are overstepping their constitutional role, and they were legislators. I think it's very dangerous for accountability and the rule of law. And that's a very difficult thing to get across without sounding very dry, which is why I think your book is so good. that, you know, we lawyers talk endlessly about the rule of law, but not everyone quite gets it.
I agree with that, and I agree with what Helen just said. And actually, one of the things I thought was particularly disturbing about the whole saga about the activist lawyers, I signed that. I was one of the academics, and was very happy to do so. But it was the government's response, you know, so the thing did actually get quite a lot of airtime on the Today programme and in the media more generally. And Lord Thomas gave a terrific intervention about it. And one of the things that was, I think, very dispiriting was the Downing Street response was exiguous and, in a sense, almost intentionally insulting, because actually what it said is no one's above criticism. And look, nobody claims that the judiciary is immune from criticism. I mean, academics criticize judgments, judges criticize other judges' judgments, legal correspondents engage in constructive criticism. And that's part of the thing, that's part of what we do, but in the right spirit, in making informed statements or trying to make informed statements about the trajectory of a body of reasoning, etc., and whether it's really well directed. So no signatory, none of the 823 signatories or whatever it was to that letter thinks that the judiciary are above criticism. But this was, you know, what the letter which prompted the 823 signatories was all about was very much something which was quite different from that. It wasn't about the judiciary claiming to be immune from criticism. It was about this idea that lawyers who were very much on the whole, just defending their clients in the light of the legislation which was existing. So if you were an asylum seeker saying you went to see a lawyer, then you were entitled to the best legal advice you could get based upon the rights and duties set out in the existing legislation. No different from if you were a corporate firm seeking tax advice from lawyers about, you know, what's the best, you know, what do I have to pay or not pay in the light of in the light of the relevant tax laws. And then for the body of people on the front line to be characterized in a negative way as being activist, and using the term activist in a pejorative way, was, I thought, very damaging. Listen, I need to sign off and leave some time for Q&A. I'd just like to make 2 points by way of conclusion of my little bit. One is just to come back to the point I said at the beginning and just to reinforce it. I do think this is a very valuable book. And I do think it's unique because it is actually getting across to the general public, the interested, and it doesn't have to be informed general public, the nature of judicial reasoning, and as Kate said at the outset, the difficulties that judges face in a variety of fields. And I think they know that one of the great things between the two bookends of Miller 1 and Miller 2 is just the plethora of different fields in which genuinely difficult matters of interpretation arise, which confront the courts day in, day out. And I think you do a terrific job in getting that across. And that's one point I'd just make by way of conclusion. The other point I would want to make, and this does come up in the book, but I would just sort of think it just needs to be emphasized to the informed public again and again, is that courts in the UK in public law, again and again, every day, show deference and respect, or whatever term you want to use, to the legislature and the executive when they're making judgments. You can reel off whole lists of big Supreme Court cases where they've said it. You know, Michelak misbehaving, Denby, Animal Defenders, Hooper, Bank Mellat, I could fill up multiple footnotes, as it were, with judgments just from the Supreme Court and the Court of Appeal when they've made clear that they understand the boundaries of what they should be doing. And one of the things I've always felt, one of the many things I've always felt about the JPP project is the very, as it were, I just think, they want to fasten on what they regard as one controversial case like Unison. I actually think Unison was a perfectly good judgment and absolutely right in the Supreme Court, as you do. But they want to fasten on one case, and then they want to say, okay, what they were doing was, in that case, was replicated or represented across 1,000 other cases. So we have 1,000 other Evans out there, which was a more controversial case, I accept. And that just isn't the picture of what courts are doing day in, day out. So thank you very much for this valuable contribution.
Thank you.
Thank you, Paul. And I think that just to a kind of coda to what you've just said, which is that the consequence of depriving courts of these kind of powers is actually to increase the power of the executive very often in circumstances where it won't be overseen. So inevitably there are going to be some bad judgments and some judgments we disagree with, but it is an important part of the rule of law to have that form of accountability. Now we've got an array of really interesting questions, so I'd like to just turn to those. The first is from the founding donor of the Bonavero Institute, Eve Bonavero, who thanks you for your timely defence of the rule of law and independence of the judiciary, Joshua, and then asks a personal question, which is whether you think yourself as having spent a career in law or in journalism, and whether you have any regrets, and do you see this book as a kind of quite a major contribution, somewhat similar to Tom Bingham's book, as being in defence of the rule of law?
It's very kind of Eve Bonavero to say this. In terms of my own career, I trained as a lawyer in order to give it up. I do regret not having trained as a barrister rather than a solicitor in various ways, but I didn't think I was clever enough to be a barrister. The barristers I knew when I was thinking about this were the people who did all the thinking, and the solicitors I knew were the people who did all the paperwork and the administration. And this is because I hung around in fairly, not in city firms, but in local solicitors' offices. And I thought I was better at running things and organising things and handling things and actually doing all the thinking. But I think I might just have managed there are certain areas of the law, presumably criminal law, where I might just have been able to get by. So I regret not having gone to the bar. I don't think there's any possible comparison between my book and Tom Bingham's book. Tom Bingham's book started with an original idea, which is so simple, what is the rule of law, that everybody thinks, oh, why didn't I think of that? And of course they didn't. And he also makes the point in his preface that when he gave his lecture, nobody apart from one journalist on The Guardian took any notice of it, because it all seemed so obvious and straightforward, all he's doing. I mean, he made it seem so easy in his lecture and then in the book that followed, that nobody really thought it was anything dramatic. He made one or two quite controversial speeches in his time, one to the Bingham Centre, as I recall, but this seemed so obvious, so sensible, so that you didn't realise how original it was and how unique it was. So no, I don't compare myself with Lord Bingham, but thank you very much for the compliment.
Well, thank you, Joshua. And then I want to turn to another question put by one of our listeners who points to a press report from last month, or in fact from September, where a judge, Keith Rayner, who sat in the Woolwich Crown Court, had on 2 occasions refused to extend custody time limits for defendants in circumstances where criminal trials had not yet run. And he was due to hear another remand case, and then the story says that he was actually removed from it and a High Court judge was appointed to hear the matter. And clearly what the questioner is wondering is whether this is an indication of sort of interference and pressure, and particularly in circumstances where, the long remand periods in custody are a real human rights issue.
I think this is a very difficult question to answer, and one reason it's so difficult is I don't know any more than is in the public domain. But yeah. let's sort of start with a few first principles. There is no doubt that if the circuit judge had made a decision and if it had been challenged, then a more senior judge or a court comprising more senior judges could have overturned it. And we accept that. So we do accept a hierarchy of judges, and we do accept that senior judges can overturn decisions of junior judges. Is that different from a senior judge sitting in the seat of a more junior judge and taking over a case? Yes, it is. Is it the job of more senior judges to ensure that the courts are run properly and the law is properly applied? Yes, it is. Should this judge have been ousted for his views, not for his opinions? Should he have been ousted because he might have given the impression that he wasn't prepared, and I suppose I should choose my words carefully, to apply the law in the same way that more senior judges thought the law should be applied? That's very difficult, isn't it? Did the right result come in the end? I think probably yes. Is the judge entitled to feel aggrieved having been ousted? Yes, I'm sure he was. Is it the job of senior judges to make sure that the system works? Yes, it is. Have I ducked the question? Yes, I think I have.
Yes, you certainly parsed out the arguments on both sides very clearly. Turning then to a question I think must be on all our minds, given the election that's happening in the United States at the moment, which is that, you know, watching the run-up to the election and the appointment to the US Supreme Court, one couldn't but conclude that both the appointment process and the judiciary, and particularly the Supreme Court, has become embroiled in kind of very a deep political contestation, and whether what we're seeing in the UK is sort of the emergence of that sort of contestation, and there's something that ought to be done about it, or something that can be done about it. I mean, the questioner says that he or she certainly hopes not, but just what your thoughts on that is.
I have a very clear thought on that. I don't think we are anywhere like the United States in the United Kingdom. And I gave the example of the fact that Lord Reid became president of the Supreme Court without anybody noticing. The president and the deputy president are from Scotland, and nobody's raised an eyebrow about that. Nobody knows anything about the new members of the court, or indeed the existing members of the court. Perhaps, you know, we know about Lady Hale, we know about Lord Kerr, they've left. And nobody's very interested, because it's assumed that all members of the Supreme Court and all the other courts are all going to behave as judges do and are not going to be political, and long may that continue. And nobody seriously supports the equivalent of the Senate confirmation hearings that Justice Barrett had to go through in the US, which she handled very well, not least because all the judges, and I do refer to this in the book, are going to decline to answer questions, or answer questions disingenuously by implying that they're only umpires and they don't make the law, which is where the book starts. But it is significant to bear in mind the very obvious and basic point, which is that the US Supreme Court can overturn legislation and the UK Supreme Court cannot. And therefore the US Supreme Court matters more. And the only other point I would like to make is I don't think that anybody can rely on judges in the Supreme Court of the United States acting in the way that the presidents who appointed them expected them to act. I think they have, over history, acted much more neutrally. I think they're influenced by other judges, and you can't assume that they're going to act politically in all cases, although obviously the case of 20 years ago, challenge to the election, hanging Chads, was decided very clearly on party lines.
That's right. So there's a slew of really interesting questions. I'm just going to pick one last one because we're running out of time, and it's about the Internal Market Bill. And the questioner says, that he or she doesn't know if they're up to date on the progress of the bill since Lord Judge's amendment in the House of Lords. Subject to that, where do you see the bill going in terms of Part 4, as I think it is with regard to Northern Ireland? I appreciate it may be dependent on the ongoing negotiations between the UK and the EU as to Brexit. Do you think the controversion provisions in relation to a breach of international law and the ouster of judicial review will be reinstated and ultimately become law?
Lord Thomas knows more about this than I do, but what I know is that this is due to come up in the House of Lords in committee on Monday. I spoke to Lord Neuberger, who supported the motion of regret, and he said that if nothing changed, he thought he would vote down the bill in committee. And I think the prediction is that the bill will be voted down in committee. In other words, they're not going to wait till report stage in the House of Lords. And then the government has to decide what to do. If the Brexit negotiations go as the government wants, then maybe the government won't need these provisions. It'll be a while before the bill finishes in the House of Lords and gets back to the House of Commons. What is entirely clear is that there is no time for the government to use the Parliament Acts to get this onto the statute book by the end of December. But John Thomas may know better than I do.
Well, I'm just going to turn to the panel and see if anybody wants to comment on any of the questions that I've put to Joshua or on anything else before we finish off.
I'm advising on the internal markets bill, so I will be silent on that one.
All I will add is that obviously there is a very strong feeling, I think, amongst an awful lot of people on all sides of the political spectrum. You must remember what Michael Howard has said about it, that this piece of proposed legislation is simply wrong. And I think that the fact that the Treasury Solicitor resigned, that Lord Keane, an outstanding lawyer who tried to help the government out of the mess, had to go, is a very sad commentary on something that's happening in our country. And that is a failure of government to understand the importance of convention and these basic principles in the way in which we run our country. And I do think it's that change in attitude that is going to make the life of the judiciary so much easier. I think we ought to be sure to thank Lord Woolf in particular for embedding the Judicial Appointments Commission, which means that we have as strong a safeguard as we can against political appointments to the judiciary.
Could I just add one point to this about the Internal Markets Bill? I agree with everything that has been said about the critique of it from rule of law perspective and from the failure to uphold an international agreement, etc. The only one point I'd add, which is I think quite an important point, but is often lost sight of here, is that the claimed policy or purpose behind the Internal Markets Bill, which is that, well, we've got to safeguard the UK internal market. We can't have a situation in which we'd have differential rules applying to different parts of the UK internal market. And that's the substantive justification for these provisions. Is, with respect to the government, wholly extraordinary in the following sense. It's wholly extraordinary for the following reason. I spent half my life being an EU lawyer and half my life being a public lawyer, and wearing both hats, but wearing my EU hat in particular, I followed through assiduously all the negotiations leading to withdrawal agreement number 1 and withdrawal agreement number 2, and I know the Northern Ireland Protocol backwards. I really do. Now the salient point is this: for 3 years, ever since this issue has been discussed between the EU and the UK, the assumption, the factual assumption behind the Northern Ireland Protocol, both in withdrawal agreement number 1 and withdrawal agreement number 2, is that the same rules were not going to apply and could not apply, which is why you needed a Northern Ireland Protocol. The Northern Ireland Protocol is based substantively on the assumption, and that has not changed in withdrawal agreement number 2. The details change, but the assumption is still basically the same. It's based on the assumption that both tariff rules and product safety rules, as they pertain in Northern Ireland, are not going to be the same as in the rest of the UK. And that differentiation was a differentiation, that assumption was an assumption irrespective of whether we ended up with a trade agreement or not. So the assumption behind the Internal Markets Bill that everyone has suddenly realized that there, because different rules would apply to Northern Ireland and the rest of the UK, is just fact. There were going to be differential rules, and that those differential are irrespective of whether you agreement or not. Thank you.
Thanks, Paul. And I mean, now it falls to me, I apologize to the questioners who put in wonderful questions that we can't get to, but it's important to try and run on time because everyone's got a busy life. And it falls to me to thank Joshua and Lord Thomas and Paul and Helen for a really interesting conversation. Joshua for a great book, which I recommend to everybody. I think we put into the chat the promo code, so have a look there. Just to remind everybody to keep an eye on events at the Bonavero Institute. We've got a range in the coming weeks. So thank you very much again, Joshua. Thanks, Lord Thomas, Paul and Helen, and to all our listeners who've been here this evening listening and for your great questions. And now it's good night.
Thank you.
Bye.